before we begin, I'd like to talk to you a little bit about myself. My name is Sherry Tucker, and I am the founder and owner of Tucker Legal Services. I have been licensed since 1991 in Arkansas, in 1992 in Missouri. So I've practiced estate planning since 1992. I've had my own firm, and I did school law back in the day. But today, my whole focus of my practice is estate planning and elder law. Today, I want to talk about powers of attorney specifically for senior citizens, really the age 50 and up, because there are some different items that we put in powers of attorney that will address specific issues in elder law. So before we begin, let's talk about what are powers of attorney. How many of you know what a power of attorney is? Not sure? Okay. Well, powers of attorney are the three most important documents that you should have even before a will or an estate plan. Powers of attorney are financial, healthcare, and it includes the Advanced Healthcare Directive. You name a person that will help you take care of finances or with your healthcare decisions or even end-of-life decisions. So powers of attorney are important because without them, if you don't have a financial power of attorney or a healthcare power of attorney or an advanced healthcare directive, then people don't know who you would like to help you take care of finances, medical decisions, or end-of-life decisions. If you don't have one and something happens to you, then what happens then is that your family members or friends will have to go to court to be appointed a guardian or a conservator. So a conservator takes care of finances, a guardian takes care of health care and advanced health care directives. If you have a person that you would like to help you and you don't name that person, the court can choose someone else. So, having these three documents is a preventive measure. It protects you. Does anybody have any questions so far? Okay. All right, so let's look at, when we're talking about why you need a power of attorney and what people think they already have as a right. So let's say life decisions, end-of-life decisions. If no one has an end-of-life decision, which is an advanced health directive, also known as the living will. More people know it as the living will. So if you don't say, this is my belief and how I want to do an end-of-life decision, you're leaving it up to someone else to make that decision for you. And it's very difficult. I mean, we've heard of cases where the person has been hooked up to a ventilator and to the heart pump and they have the oxygen, they're getting the tube feeding, and so they're basically in the vegetative state, but they're not getting unhooked, all right? So that causes a lot of anxiety when you think about it, is that you have a loved one who is there going through a slow death process and being kept alive through mechanical means. But if you have the end-of-life decisions laid out, then you can talk about what if you want a ventilator, if you want CPR, if you want tube feedings or hydration. So those are important things that are laid out. For seniors, these three documents are very important, and the Advanced Health Care Directive has some special language that also protects senior citizens. So when we're talking about your spousal rights and your parental rights, the powers of attorney are those documents that give you the legal authority to take action on behalf of your loved ones.
Can
So these 3 documents can keep people out of the court system. And it also, they name a trusted person. Let's go through just like some of the financial and what we see that's different for senior citizens. So a financial power of attorney will be different for an 18-year-old than it will be for an older married spouse. So if I have a power of attorney for an 18-year-old, right, they may not own much unless they're, independently wealthy from an inheritance. But usually we're talking about a little bit of a bank account. Maybe they have a car if it's not, in somebody else's name. Maybe they have the social media accounts, so digital assets, all right? So if I do a power of attorney financial for a young adult, I'm going to say, okay, who do you want to help access your digital assets, your social media, Facebook, your photographs, your books, your music, all the, your Twitter. And then what about your bank account? Do you have a payable on death, or do you want someone to be able to come in? Do you have a credit card you need to pay? And usually the 18-year-old is going to name mom and dad, all right? Well, that power of attorney financial is just a bare bone basic, but it's still, they're an adult, so it's going to help the parent be able to step in. Married couples and young single people will have a financial power of attorney, and they'll have a little bit more like credit cards, bank accounts. Maybe they have a business and they need to do a business, the agreements, and help wind down a business. So they'll need someone to step in and take care of business, banking, their digital assets as well. Okay. Now, a young married couple, spouses in a financial power of attorney, the spouses become an automatic power of attorney unless stated otherwise.
But only for financial.
For financial, just financial, because we have different documents. It's better to always have the separate instead of an overall durable. Okay, and I'll talk about that in a minute. But so unless the spouses are like, no, I don't want to make this an immediate power of attorney. I want it to spring on incapacity, all right? And then we do some different wording in that. But when you get older, this financial power of attorney becomes enhanced. It has more powers that are in it. It's as if you step exactly into my place and act as I would on my financial matters. You have access to everything, okay? In addition, a financial power of attorney for senior citizens includes giving the authority to an attorney-in-fact, an agent, to operate all the business accounts, to also be in charge of investments, so all the securities, investment procedures. It also says, okay, you can create a trust on my behalf. So your attorney-in-fact can hire a lawyer and create trust for the person in case of incapacity, especially. Why is this important? Because sometimes this senior, let's say maybe they have an early diagnosis of dementia or another mental incapacity, right? So there'll be a mental decline. And maybe they don't have good health care, maybe they don't have good finances, or maybe they have too much but know that they're going to need Medicaid. So the person you name that you trust fully with your money can step in, hire an attorney, hire CPAs, hire investors, and create like a Medicaid asset protection trust to help protect assets. Maybe there's no trust at all. no revocable living trust, this person can step in and create a trust on behalf of that person. So, senior citizens have their own medical health challenges and circumstances in life. So you need to be able to trust someone to come in, take over the finances, create trust, and hire lawyers, hire CPAs on your behalf. So it's a very extensive power in the financial power of attorney. So you have to really trust the person. What is a drawback? You want to think of a drawback?
I mean, are these financial powers of attorney though, are they valid, or are they valid while the spouse is completely fine, mentally capable, or not? That's what I'm kind of wondering about.
They're valid. Once they're signed and notarized, they're a valid document, all right?
Mm-hmm.
They can be revoked, and there's also wording that it can be amended.
But what if I sign a financial power of attorney, married, have a good marriage or whatever, but all of a sudden the wife starts to steal money or transfer money out of bank accounts to other bank accounts because she can show this financial power of attorney document? How do you prevent that from happening?
You revoke it. You immediately revoke, take her name off as power of attorney, and have another set of documents.
I guess my question too is why would you have a financial power of attorney like that? Why wouldn't you just have a financial power of attorney that says, in the event I become incapacitated, you have the financial power of attorney?
You can state just in incapacity, and that would mean it would spring. You could say, okay, even to my spouse, only if I become incapacitated. All right. Incapacity, when we're talking about incapacity, it takes 1 to 2 physicians to declare a person mentally incapacitated. Right? So then what your attorney in fact is going and doing is that they go and get you declared incapacitated so that this financial power of attorney springs. So it's just a layer. But for some people who want that, they feel it's a layer of protection. So it's really good, especially if people do have a lot of assets. Maybe there's been trust issues in the past, so they want to have that layer. The other thing too is you can have a code. You can have 2 people acting, and you can put that they have to act jointly and agree. All right. So that would also protect maybe that independent action taking place. One of the fears for seniors is what if you name a person, and sometimes it tends to be the adult child, so you have like maybe a 65-year-old who is showing an early prognosis of dementia, all right, and he's named a child who's pretty good with money. Maybe this person starts taking the money and misusing it, all right? Who is to stop the attorney, in fact, who's named when you have an incapacitated senior? So those are some of the issues that we see that do come up, but there are ways to help that senior citizen, right, who is incapacitated and has trusted the wrong person. So it does mean, of course, legal work. Okay? But without it, you're having to go through probate court and get a conservator appointed. So the financial power of attorney, even though there may be some drawbacks, it's important that you trust the person, but there's also safeguards that you can build in those layers of protection to help But if you don't have a financial power of attorney and you become incapacitated, even if you're a spouse, right, you end up in court. A spouse is not an automatic conservator. Okay? So this financial power of attorney, pretty much, it helps the marriage in different ways. It's just, there's a, for instance, no powers of attorney, wife gets Alzheimer's, ends up in probate court, husband is conservator, right? To be a conservator, you have to follow all these certain steps and legal processes. It doesn't end. Just because you're named, you're always in court doing an accounting of assets, how you spent the money, what's coming in, and if you don't do it timely, conservatorship is taken away. And even if you're the spouse, okay, it's taken away. And then what happens is any money that was coming to the spouse as part of the marital portion goes back to the incapacitated person, especially if they're in nursing care. So it could actually impoverish a spouse when they lose control over the monies of an incapacitated husband or wife. So these powers of attorney, especially for senior citizens, are very important, of course.
I want to go back to a comment that Morris made. So in the case of a situation where the person that has been appointed as the attorney, in fact, turns out not being the right choice, and the person who granted the power of attorney is incapacitated, so he cannot or she can no longer revoke or amend the power of attorney. Who steps in to make these changes? The family in court?
It's usually someone who will have a suspicion or see something that's going on and will step in to enforce some changes being
In
made.
court?
In court. Mm-hmm.
So in the meantime, this person that turned out to be not good still has the power of attorney.
Still has the power of attorney, yes.
Until there is a decision from a court, like an injunction, so that,
Right, to get stopped. You know, and the other thing too is when there is a suspicion of financial abuse, all right? So elder financial abuse is a crime in the state of Missouri, and it's reportable, okay? So if someone suspects that an attorney, in fact, is abusing their authority for finances with a senior citizen, especially, it's reportable. It's investigated. All right. Unfortunately, most elder financial abuse cases are not being reported. But just to reiterate, there is a safeguard that is allowed or comes into play when that type of action is taking place. That despite it all, even though there is a possibility of abuse by an attorney in fact, that there are actions and there are steps that can be taken that will rectify the situation. And it's legal, but it's still better than not having any power of attorney in place. Okay. So that's the financial power of attorney. Any other questions over the financial power of attorney? For the financial.
But the financial power of attorney, the document would be very similar regardless of whether the person you're naming as a attorney in fact, whatever, is a live-in or a spouse.
Right. Right. It could be a very good friend. You could say, none of my children and my spouse are very financially savvy. I don't think that even if I turned over my finances to them, that they would know what to do, okay? But you have a brother that is really great at finances, and you say, I'm going to name my brother. So the other important thing is, and thanks for that question, is that when you do name a person, you want to name another person behind, a successor that you trust as well, because that person, your named trusted person, number one person, something might happen to him or her, and you need a fallback, all right? But the good thing is, I do write my financial powers of attorney where they can be revoked and also amended. And then you can have them where they're immediate or springing. And you can have where they're being accepted. And also, I do a certification when you want it to start going into play. So some people, before they're having major surgery, they'll get their financial power of attorney and say, okay, I am going to put this into play right now. Okay. So on the financial powers of attorney, you want to name your trusted person and also have a successor. All right. The other thing that I do in my powers of attorney is I have an acceptance. So basically, what good is it to name someone if you have not talked to that person and said, hey, you want to be my attorney in fact or my financial power of attorney? And that person, what if they say no? And then what? I mean, you can't force a person to be your attorney in fact for financial. So I say, please talk to that person, and I have an acceptance of the attorney, by the attorney in fact, that is signed and dated, signed, and notarized. Okay, so everything is right there. All right, so let's move into healthcare. All right, healthcare powers of attorney are different for senior citizens than for the younger people. Okay? The reason for this is just because of the types of health decisions that might come along. Now, I will say that not only senior citizens, but people with a disability, physical, mental disability, also need a very substantial powers of attorney. So in this healthcare, you want someone who is empathetic and understands your health situation and will be able to work with your medical caregivers on healthcare decision issues, all right? So they're going to understand. Also, you need someone that you trust to access your medical records, because along with this healthcare power of attorney is the HIPAA form. And so that person will be able to access medical records on your behalf and talk to doctors. They can call doctors and talk to them. So why is this important? Well, for instance, I have a client whose mother has stage 4 pancreatic cancer, right? She had no documents in place. We have all the documents in place now, and the mother has finished chemotherapy and doesn't want to tell her children what the doctor has now said. And her response to their question was, call the doctor. So this healthcare power of attorney has become an important document for the adult children, because they're dealing with a parent who doesn't want to talk about the diagnosis as of yet, and they want to know, well, what is going on? So there are situations that parents don't want to say, or spouses don't want to say what the medical condition is. Maybe emotionally they can't handle it themselves, and so that power of attorney can step in and talk to the doctors. The other important part of this is when you do have a senior citizen who has been diagnosed with dementia and Alzheimer's. I mean, many of us don't understand this diagnosis can occur at the age 50. It's a different kind, it's a frontal lobe, but it can occur at age 50. even in the age of 60, you can have such a mental decline, and it can be rapid. So Alzheimer's, don't just think that it's a 70 or 80. It starts from age 50 and up, but it can be a slow or it can be a rapid diagnosis. So this healthcare power of attorney allows that person to talk to the doctors and also to understand what's going on, especially when you get closer to the hospice need. So they can bring in your caregivers, they can also look at the end of life decisions. So in the healthcare, you want someone who has empathy, but also who is going to make sure that your end of life decisions are handled.
So I'm a little confused. What is the difference between the healthcare power of attorney and the advanced health directive?
The advanced health directive, you could do a separate document. How I handle it, it is part of the healthcare, so that you have the same person who knows what your health situation is, who's talking to the doctors, to just make sure that your end-of-life decisions are being followed, all right?
So if you just had a healthcare power of attorney without any advanced health directive, the person who's been appointed the attorney for the healthcare power of attorney does not necessarily have the right to make decisions, right? They have the right to hear what's going on, to talk to the doctors, but not necessarily make end-of-life choices.
Not necessarily, but they can, because they understand the situation. In the wording that I include, it's that you understand, and here's some things that I want you to understand about me, and this is some things that I want you to consider on the end-of-life decisions. So it tells the attorney in fact some of those considerations that you have, all right, about end of life. So the advanced health directive is really to help with the natural process, natural death process.